All right, good morning, everyone. It's a pleasure to be with you today and have the honor of having with us, for the second time in 2 years, really, Professor Tarunabh Khaitan, who is an associate professor and a Hackney Fellow in Law at Wharton College at the University of Oxford in England. Tarun is also an associate of the Oxford Human Rights Hub. Just to give you a bit of his background, Tarun is originally from India and a citizen of India. He did his undergraduate studies, that is his BA and LLB at the National Law School, University of India in Bangalore, India, I think still preeminent law school. And he then came to Oxford as a Rhodes Scholar and did his BCL, which he got with distinction, his MPhil, which he got with distinction, and his DPhil. I guess they don't give distinction for DPhil, so, but I'm sure that I've been with distinction otherwise, also in Oxford. He is the author of a monograph entitled The Theory of Discrimination Law, which he talked to us about last year. Since then, the monograph has really gotten a lot of fantastic press. Sophia Morrow at the University of Toronto states that in this magnificent and wide-ranging book, Tarunabh Khaitan attempts what very few others have tried. In the Modern Law Review, Casper Lippert Rasmussen claims that Khaitan's account is sophisticated, extensive, and among the best normative accounts of discrimination law available. And so you just get an idea. The field is very sympathetic to Tarun's work. Tarun is currently a Global Hauser Fellow at NYU, which allowed us to bring him over for this talk today. I think really today Tarun is getting back to his first love, that is the Constitution of India. I think Tarun has always, even though he's based in the UK, has always been quite concerned by what is happening on the legal and constitutional front in his motherland. And so he's going to talk to us today about, indeed, you've revised the title of your talk now.
I'm thinking about it.
But thinking about him, so the official title that we were given, you can find on the board, Securing Losers' Consent for India's Constitution, the Role of Directive Principles. And I had a glance at his notes, and it seems that the title is evolving towards Securing Dissenters' Consent. So maybe we're going to get a sense of what this means. But it's quite fantastic to have you here today, especially since at Osgoode we've been thinking more and more about what is happening in South Asia. Sana is here in the room, who's a PhD student from Pakistan. We also have an advisory board that tries to take the pulse of what's happening in the South Asian community in Toronto and in Canada and how we can do more to become involved with them. So it's fantastic to have you today presenting on a topic that's really going to interest a lot of people here. So thank you very much, and the floor is yours, Tarun.
Thank you, Francois, and thank you all for coming. I clearly enjoyed my last visit enough, so I keep coming over to Osgoode Hall, and with that generous introduction, it's hard to say no. So so today, let me start with some background about the motivation behind this paper. So, you know, I finished the book on discrimination law, and I was thinking about doing something else. And one of the issues that Indian liberals have been somewhat embarrassed about for a long time is certain seemingly bizarre provisions in an otherwise liberal democratic constitution, a constitution that most progressives would happily sign up to. And these are provisions which ask the state to endeavor to secure the prohibition of on the consumption of alcohol, that require the state to try to secure a prohibition on cow slaughter, and other such provisions on these slides, right? And these provisions are found in a particular chapter of the Constitution, which is Chapter 4 of the Constitution, which is called Directive Principles, and I'll tell you in the course of my talk what they are and what they mean. But the project was motivated by trying to understand why they found their place in the Constitution. And therefore, I went back to the original debates at the framing of India's Constitution and discovered that rather than constitutional embarrassments, these really were constitutional triumphs, that these particular provisions may well have played a very significant role in enabling India's liberal, well, they weren't liberal framers, they were mostly socialists who came up with their liberal constitution, but enabled the framers to get this constitution enacted and get a wide consent of various groups around the constitution. François told me that I should give a brief overview of India's constitution before I go into the talk, so I'll do that. But if I say something which doesn't make sense, please feel free to interrupt, and I'll be happy to explain it. So India wrote its constitution between 1946 and 1949. The constitution was finalized towards the end of 1949 and adopted officially in January 1950. So 1946 is when the British government decided the Second War has ended, Labour Party has come to power in Britain, and one of the agendas of the Labour Party is to grant independence to British India. 1946 is when elections to the Constituent Assembly of still undivided India take place. These elections, and this is crucial for some of the arguments in the paper, these elections are not based on full franchise. They're based on a limited franchise, a franchise limited by tax, education, wealth, and other such features. So they're under a limited franchise under the colonial government. And the franchise for the elections to the assembly are also indirect, in that the limited franchise is used to elect provincial assemblies, and the members of these assemblies then elect the Constituent Assembly. That said, India's first general elections take place in 1951, and on universal adult franchise and direct elections, and the outcome is not particularly different. So as a counterfactual, things may well have turned out to be pretty much the same way, which is that the Congress Party overwhelmingly won the elections. Right? Now, of course, the Muslim League, which at this time was calling for the creation of Pakistan, also does really well in the Muslim majority provinces of British India, but the Congress gets a majority. Now, the League decides to boycott the assembly. Its members don't join the deliberations of the Constituent Assembly, and for the first few months, I think about 7 to 10 months, I don't have the figure in my mind exactly, the assembly with largely Congress members does no substantive work. So it's just waiting in the hope that the League will come back, and they don't want to present any fait accompli to the League on any substantive matter because that will annoy the League even more. The assembly starts doing substantive drafting work only after partition of the country becomes a foregone conclusion. And that's in the middle of 1947, and events move extremely quickly. The British government basically decides to cut loose and run as quickly as it can, unleashes a whole reign of violence and terror across the two countries, and the entire administration of a couple of centuries is dismantled relatively quickly. That political context is also important to what the assembly is going to do. This is also a globally unstable time. The Second War has ended, but the Cold War is beginning. The members know that the world is dividing up into the two blocks, into the American and the Soviet bloc, and there's a lot of pressure on other countries, especially the newly decolonized third world countries, to join up on either side. So there is that global context, and of course, it's also a context where socialism has become really attractive for newly independent, decolonized nations. It's a context where not only is the country dealing with great religion-based violence, British India also had sort of semi-sovereign relations with a number of what are called princely states, about 500 odd little kingdoms who were semi-autonomous, and the British government, in its hurry to leave the country, gave these little kingdoms the choice to join either India or Pakistan or remain independent. So, and some of those kings actually tried to, against the wishes of overwhelming wishes of their people, to gain independence, and Kashmir was one of them. So some of those conflicts have still not been resolved. So the country is dealing with all of this, and father of the nation, Mahatma Gandhi, is assassinated in early 1948. So it's an extremely fraught time in which the Assembly is writing the Constitution. Now, once the League leaves, partition has happened, the rump of the League that is left behind in independent India is part of the Assembly. The Congress members, however, are not all Congress people. So largely because of Nehru's efforts, Nehru, India's first Prime Minister, he knew that any legitimate constitution for the country has to have extremely wide support. So at the elections, during the elections for the Assembly, the Congress Party made it its official policy to invite political foes, opponents, people outside the Congress, to join the Assembly, either on the Congress ticket directly or supported by Congress, where Congress does not put a member of their own, but supports the election. In fact, Ambedkar, who we'll see goes on to play an extremely key role in the framing generally and in the question that I'm interested in, was himself a political opponent of Nehru and Gandhi for a very long time, and he's elected first on a League ticket from Bangladesh, what is now Bangladesh, and once partition happens and he loses his seat, the Congress then supports his candidacy from Bombay and makes sure that he joins the Assembly. So there's already an effort in the Congress. We can see from its decision not to start doing any substantive work and wait for the League, and also its effort to bring in as many groups as possible to the table, that there is an understanding that this is not politics as usual. There is an understanding that constitution making is a different task that requires a different type of approach, and you can't, and the winner cannot take all, the winner must not take all. So there is a sense that you have to make compromises. Just a few other comments on the political context. The key groups that we are going to look at include the socialists. Now, the Socialist Party officially decides to boycott the Assembly as well, on the ground that it's not elected directly through universal franchise. There's a lot of back and forth between Congress and the Socialists. Nehru tries quite a bit to convince them to join, and there's a half-hearted reversal of the policy. The Socialist Party decides to join and then overturns the decision again. Anyway, it equivocates, but the sum of it is that some prominent socialists, both from within the Congress and outside the Congress, do end up in the Assembly, and the socialist voice is represented quite strongly. Hindu nationalists, again, the Hindu Mahasabha, which then represents the Hindu nationalists, is not formally member of the Assembly, although one or two of its members are part of it. But because the Congress itself was a broad church, a lot of their views are represented by people like Purushottam Das Tandon in the Assembly. And the third dissenting group that we'll look at are the Gandhians, who don't have any presence as a political formation outside the Assembly, but they are a key group within the Congress, and obviously relying upon Gandhi's immense personal authority, recently assassinated Gandhi's personal authority to push their agenda. So this is the context in which the Constitution is being framed. Now, the key leaders in the Assembly, they're largely of a left progressive bent. They have socialist views, but they're also Democrats. So to capture their, it's hard to put a single label on them, but to capture their political values, I think Ambedkar, in one of the speeches he makes in the Assembly, he says, in India we need both political democracy and economic democracy. He says we have to have one person, one vote in political democracy in the Western sense, and an economic democracy where wealth is not too unequally distributed. So they see this middle path as the best of both the American and the Soviet
model of governance. At least that's how they envisage this new state as ideologically committed. The assembly sets up various subcommittees. So the assembly first discusses an objective resolution that Nehru presents, this broad framework of what the constitution will look like, which is, because it's at a high level of generality and abstraction, it's passed in 1947. And then the assembly starts working on a draft through its various subcommittees. And these subcommittees are then they report to the drafting committee, which is chaired by Ambedkar. Now, Ambedkar is a lawyer. Ambedkar is one of the finest legal minds in the country. He's also the first, what we would today call Dalit, but then called former untouchable caste member who goes to Columbia, gets Columbia University in the U.S., gets a doctorate, comes back to India. So he's the most important leader of the lower castes. And he's also one of the finest legal constitutional brains in the country. And Nehru appoints him as his own law minister despite their political enmity and tasks him with the chairpersonship of the drafting committee. Now, the drafting committee comes out with a liberal democratic draft constitution in early 1948. And this constitution, so it has an enforceable Bill of Rights, which gives immense powers to the judiciary, modeled largely on the American Supreme Court, including the power to strike down laws. It adopts a parliamentary Westminster form of government, like in the UK, with an indirectly elected nominal presidency, whose powers are modeled on the British monarch, but maybe with slight more discretion in certain areas. And with significant political accommodation for certain minorities. So there is a requirement of very robust affirmative action program for lower caste groups in the Constitution. Religious minorities are guaranteed a significant degree of cultural and educational autonomy, but no special political representation. So the Congress sees special political representation for Muslims during the British Raj as one of the reasons that gave rise to partition. So that the separate political franchise is ended, so that there will be one single unified franchise, but other cultural interests are protected, and there are significant non-discrimination guarantees. One of the unique features of the Indian Constitution, one that it borrows from Ireland, the Irish Constitution in 1937 also had a chapter called Directive Principles, well, a section called Directive Principles, which did slightly different things, but the framers of the Indian Constitution, after the chapter on fundamental rights, put in a new chapter called Directive Principles of State Policy. And the draft Constitution had two different types of directives in it. The first set of directives were largely what we would today call social rights. Guarantees for universal education, for healthcare, etc. But because the framers, mainly the lawyers in the drafting committee, did not think that these should be judicialized, that courts should enforce them, they were put as directive principles. Now, directives, the constitutional directives are directives primarily addressed to the political organs of the state, to Parliament and the executive, but they are constitutional duties. So they're not things that, at least the way the framers thought of them, they were not things that the political branches could ignore. They were important, but not enforceable by courts. So there were social rights as directives, and the second type of directives were basically what Rawlsians would call the difference principle, redistributive justice. So this is what they saw as achieving their economic democracy. The state should endeavor to reduce great inequality in wealth, seek the common good, things like that. So these were the directives in the draft constitution. Now, the draft constitution remains in the public domain for about 8 months,
and goes through a lot of public consultation, etc. And then the assembly starts its second reading in November 1948. Ambedkar moves a motion to present the draft constitution before the assembly, and in that very first debate, it's very clear that there is deep hostility to this liberal democratic draft constitution from three different groups. From the Gandhians, the socialists, and the Hindu nationalists. So, and the hostility is quite significant. Speaker after speaker stands up and complains about how this constitution is valueless, that there's nothing in it for, and they're all appealing to their constituencies, but they make it very clear that they don't see themselves as signing up to this document, to this. Now, I'll stop the context giving there and move on to setting up the argument, and which will help in understanding how Ambedkar and other framers deal with this hostility. So, constitution making in deeply divided societies is a huge problem because constitutions aspire to endure, to last a long time. But this very endurance and entrenchment gives every group an incentive to be intransigent because they're locking away. If they don't get what they want, they're going to lose for a very long time. So in societies that are deeply divided, the problem is exacerbated. It's really hard to get everyone to sign up to a document, and if they don't, then the document is less likely to survive. So it's a classic dilemma for such societies. Now, the scholarship so far has focused on ethno-cultural disagreements, on societies that are deeply divided on ethnic and cultural and religious and racial lines. And most of the practice in the scholarship has looked at how those divisions can be managed by liberal constitutions, primarily by guaranteeing some sort of power sharing to the threatened minority. The classic example is the Irish Constitution, where the Northern Irish, where Catholics and Protestants have a consociational arrangement where each group has a political veto on important policies against the other. And so these arrangements, they're a type of political insurance that threatened groups seek to get. Now, in liberal theory, with a lot of work on multiculturalism, etc., this type of concession or accommodation of minorities through power sharing is not a particularly deep theoretical problem because it is in keeping with at least some versions of liberal constitutionalism. The difficulty, and India had its own share of this ethnocultural disagreements, and there were other power sharing tools that were used to deal with those disagreements, but I'm not going to talk about those. I'm interested in ideological disagreements. Now, ideological disagreements are different. They don't necessarily track group identity, except in the case of Hindu nationalists. But even I don't have data on it, but it's not clear that even most Hindus subscribed to their Hindu nationalist vision, at least then. So the other difference with ideological dissenters is that they don't view themselves as minorities, or they certainly don't see themselves as permanent minorities. If you believe in your ideology, if you think that you have got it right, then you're also likely to think that it's only a matter of time before everybody else sees the wisdom of your position, right? So they're not groups who believe that they're going to be locked out of power permanently, or they tend not to be those groups. And in the Indian context, if you think of the Gandhians, the main agenda that Gandhians were pushing for was a radically decentralized state with self-sufficient, self-governing village republics. Right? So there's an anti-modern, anti-state, autarkic vision of India with an extremely weak center and And Gandhians believe that most of India lives in villages, so of course we are going to win every election henceforth. The socialists thought, well, we are for the poor and most of India is poor, so we are going to win most of the elections. And the cultural nationalists thought, well, the majority is us, right? We want the Hindustan, all the majoritarian demands. So we are going. So each of these groups has some stake or some reason for optimism, and this is where the importance of the assembly not having been elected on a full franchise becomes important, because the Congress did not have the confidence that it will come to acquire politically in 1951. In the 1946 election, the Congress knows as well as these other groups that this is a limited franchise, and it's not clear how a full franchise will behave. So all groups are working under a Rawlsian veil of ignorance of sorts. It's come about by chance, but nobody knows for sure how they will fare. And that, I think, helps in making sure that they listen to the other and make compromises. Now, so the literature is quite weak on how liberal constitutions can accommodate illiberal ideologies, illiberal ideological disagreements, because here, unlike power sharing with minorities, you have to give up on your liberal commitments entirely if you start going too far down the line of accommodating these ideological dissenters. So that's the main difficulty that the framers in India faced. Now, just very briefly, what the three groups wanted. So I've told you the Gandhians wanted a radically decentralized government with a slightly Hindu tinge to it. They wanted a village republics where nobody drank alcohol, where cows were not killed, and so there was some overlap with the Hindu nationalist agenda, but on cultural rather than religious terms. The socialists wanted the nationalization of all natural resources, of the organization of cooperative agriculture and industry, and enforceable social rights. And they wanted all of this in the constitution. Right? So not just political enforcement later, but they wanted the constitution to settle these matters. And the cultural nationalists wanted Hindi, which is the language spoken in northern India, to be the main, the national language recognized in the constitution. They wanted a lot of Hindu majoritarian demands to be reflected in the constitution, including cow slaughter prohibition, but also a uniform civil code, so a de-recognition of special personal laws for religious minorities, and a lot of symbolic things like a national flag, the name of the country should be Hindustan, and other such demands. Right? So these are what these groups are asking for. Now, how do the framers go about accommodating them? This is where I would like to introduce the concept of incrementalism or constitutional incrementalism. Now, it's the idea that reasonably well developed of late, as a lot of this type of scholarship is quite recent, but the idea of incrementalism is doing things step by step, slowly, rather than big ticket reform. The idea is that when you go slowly and incrementally, things are often easier to achieve. The idea of constitutional incrementalism is that you divide up a decision in at least two steps, which is largely the Constitution deciding not to decide, the Constitution deferring a divisive decision to the future. So it shifts the decisional cost of settling a controversial matter from the present to the future, and from the constitutional domain to the political domain. Now, this is quite a familiar tool for constitutional drafters. It's classically reflected in by-law clauses. So, to give an Indian example, on the language question, the Constitution sets up some default but says Parliament will by law decide after 15 years what shall be the official language of the country. Right? So that's a classic deferral tool. Like we're not going to decide, things are too fraught. Maybe when we have more stability, 15 years later, we'll deal with it. Strategic ambiguity or vagueness or constitutional silence are also deferral tools. So constitutional provisions can be deliberately ambiguous. So each group can read what they like in the provision, or vague, or just not talk about a difficult issue, which by default pushes it to politics. Right? You can have sunset clauses. Say, okay, we'll preserve the status quo, but only for a fixed number of years, and then you have to go back to the political drawing room. Right? So the classic example is the question of slave trade in the United States Constitution, where they said, okay, for 20 years, Congress shall not act on the issue of slave trade, but after that, you decide. And that was also, the southern states expected to be politically more powerful than the northern states, and that's why they accepted the arrangement, and of course things turned out differently. So the Rawlsian veil of ignorance was doing some work there as well. So these are the classic incrementalist tools, but what all of these tools do is defer the entire decision from now to the future. Directive principles are also an incrementalist tool, or at least that's what I argue in the paper, but they entail partial rather than full deferral. So the Constitution, in making a demand, an agenda, a constitutional directive, does not say, we are not going to decide anything now, we'll leave it for the future. It does settle some of the questions. It settles whether this is an appropriate matter for the state to decide on. By making something a constitutional directive, the Constitution forecloses the argument that prohibition on alcohol is not a matter that the state is competent politically, morally, legally to decide upon. So it settles that question. But it does more than that. It also settles the goal, the end goal that the state is seeking to achieve. So, bylaw clauses also settle whether the state is competent to decide on the question of language, right? But they don't determine the direction of movement. Bylaw clauses leave it open for Parliament to decide what to do with the language policy. Directive principles tell the state not only that it must act, but also to what end. Right? So in making a directive asking the state to endeavor to seek a prohibition on the slaughter of cows, the Constitution is settling the whether question, whether to act question, and also what goal to seek question. But two things are deferred. When to act is deferred. The Constitution does not decide when the state ought to act. There's one directive, the Education Guarantee Directive, which did have a time limit, which said that the state must act within 10 years. But other than that, most directives were open-ended. They did not specify any timeline for the state to act. And they also defer the how question, about how the state ought to act. There are many ways of seeking this goal, and in fact, if you look at the debates, the framers are very, especially with the divisive directives, they're very keen to emphasize that these directives ought to be pursued by making, by generating a broad consensus, by making enough concessions to make sure that that people who disagree with these directives are on board before the state ought to move. So the when and the how questions are deferred. So directive principles are incrementalist tools, but they only entail partial deferral of disagreement. Now, why is this important? This is important because a full deferral would not have satisfied the ideological dissenters. It would have given them far too little. It's not enough if you're a Gandhian or a socialist or a Hindu nationalist sitting in the assembly to be told, look, the future state will deal with your problem. The Constitution is, don't rock the boat now, because it'll make things too. Now, we don't know if that might have worked or not. We don't know how willing these groups were to leave the negotiation table and to use violence. The only group that that does that are the communists. The communists launch an armed insurrection at the time when the constitution is being framed, and the state's approach to them is completely different. Right? So all these three groups who join the table are being accommodated. The state comes down with its full force and fury on the communists and uses a great deal of violent repression. And the communists actually call off the armed insurrection and join the first parliamentary elections in 1951. But anyway, that's a side story. So what this partial deferral does is it gives these ideological groups, it's still not a lot, it's still nothing substantive, their agenda is not being implemented, but it does grant their agenda a constitutional legitimacy that when they are battling it out in the political domain in the future, they can always point to the Constitution to say this is a constitutional duty, right? And to the extent that might or might not help in the political bargain is a different matter, but it's more than simply deferring the matter. So yes, it is short of a political insurance of the sort that ethnocultural minorities get by power sharing guarantees, but it's not nothing. And I've called it expressive accommodation, where the Constitution signals, lends its legitimate weight to this divisive agenda and guarantees that their agenda will remain on the state's agenda for at least all time, in near future certainly, but possibly longer than that. But liberals don't lose out either, or at least each side gets to fight for another day. Now the trouble with ideological accommodation is if you go too far, the liberal majority might decide to leave the negotiation table or might withhold consent from the Constitution. So that's the dilemma that the framers are trying to solve. And liberals still get to hold out hope of defeating the illiberal agendas politically in the future. But more importantly, well, I don't know more, but also importantly, these by constitutionalizing these radical illiberal agendas, there's another thing that Ambedkar does. It's not just incrementalization, it's not just deferral to the future. They're also being contained as they are being constitutionalized. They're being defanged, they're being de-radicalized. So to give you a few examples, some of these demands are diluted as they find way into the Constitution. So the Gandhian demand of self-sufficient villages is whittled down to self-government, but the sufficiency language is very strongly opposed by the liberals. And Ambedkar basically says this is all you're going to get. Right? Now, so the limits of decentralization are being set in the constitutional language. Or apart from dilution, another very important tool that they use is instantiation. Both cow slaughter prohibition and alcohol consumption prohibition do not make it into the constitutional text as self-standing directives. Ambedkar accepts them in the draft as amendments, but as instances of broader, more general governing directives. And these are not just broader and general directives, but also non-controversial directives. So the prohibition of alcohol is appended as an additional clause to the general directive asking the state to endeavor to try to raise the levels of health and nutrition. And in particular, seek to prohibit the consumption of alcohol. The cow slaughter directive is appended to a general directive asking the state to endeavor to organize agriculture on scientific lines. Now, what this instantiation does is that it limits the type of arguments that you can now legitimately invoke in your political battles later. Right? So to this day, the cow protectors have to rely on pseudo-scientific arguments about the economic value of cattle for agriculture, because all other arguments have been foreclosed by the constitutional framing. Right? And the third way of containing these radical demands was by qualification. So even as the Constitution half-heartedly says, okay, Hindi will by default become an official, not national, an official language after 15 years, unless Parliament decides to extend the life of English, which of course it does. But then it also has a directive to say the state shall continue. So some context is important here. Hindi is a North Indian language largely spoken by North Indian Hindus. North Indian Muslims speak Urdu, which shares about 70–80% of its vocabulary with Hindi. They are mutually intelligible languages, but Hindi borrows from Sanskrit, Urdu borrows from Persian. Now, most of the liberal framers would have liked a composite language, which is being called Hindustani, as the official language of the state. That's what Gandhi wanted, that's what Nehru wanted. But because of the Hindi nationalists, Hindi becomes the default official language unless Parliament decides to act. But the constitutional directive says the state shall endeavor to introduce into Hindi Hindustani words. And it says enrich the language of Hindi by basically erasing the distinction between Hindi and Urdu. And that hasn't really happened, but that was sort of a qualification in accepting Hindi as an official language. So this contained and incrementalized constitutionalization of illiberal demands allowed the liberal framers to get these ideological dissenters to sign up to this largely liberal constitution while keeping the constitution largely liberal. And in fact, in the closing debates, members of each group refers to these accommodations as the reason for the reluctant consent to the draft constitution. So that's broadly the argument in this paper. In the conclusion, I speculate about, and Francois's comment about the word losers. So these groups don't in fact end up being losers, in that they were right in thinking that they're not getting nothing. So some of their agendas do get implemented, and they're still in the process of being implemented, but both these features of incrementalism and containment are relevant in the future implementation. So it's a matter for another paper. I've just offered some speculative thoughts, but most of these agendas are qualified when they're implemented. They're implemented in steps, and for reasons that the Constitution has already earmarked through its various containment tools. So I'll stop there, and I'm happy to take any questions. Thank you.
Thank you, gentlemen, for a very thought-provoking picture. I can see a lot of interesting parallels and yet a lot of tensions with the Canadian model. I wonder if there are any questions in the room. Yes.
Well, thank you for a very interesting talk, and I have to say that the Indian Constitution is a magnificent achievement. I mean, I know everything's not perfect, but I'm just, one of the thoughts that was provoked by your talk was, how would you compare the U.S. constitutional provisions, say, on the right to bear arms, which is not framed in the context of a directive principle? It isn't, for example, put in the context of public safety and security. It's just a right, and it's migrated a great deal in its own constitutional law to the two particular examples, like, for example, the prohibition of alcohol.
I think that if the American Constitution framers knew of this tool of directive principles and made, instead of a right to bear arms, the state shall endeavor to secure to citizens the right to bear arms, would have been a better thing to do than the Second Amendment. So the parallels you're noticing, I think, are real parallels in that it just doesn't fit with our vision of liberal constitutionalism, and and directive principles can allow some of these accommodations to be made. But your question also triggered another thought, which is that a lot of American, not just American, but a lot of things that we think of as fundamental rights also have an incrementalist character. So things like the 14th Amendment, they all have a programmatic character. So there's a distinction I make in the paper between performative provisions and programmatic provisions in Constitution. So a performative provision in a Constitution is something that happens by virtue of the Constitution saying this will be the case, right? And the idea comes from the idea of performance in contract. By promising you something, I'm also actually promising you something. Or in marriage vows, saying I do means that you are married. So that the idea of performance in constitutions, for example, the Constitution simply by saying that, like the Indian Constitution does, that all existing colonial laws shall continue to have the force of law in independent India, that's a performative provision. Simply by saying that the Constitution grants on all this huge body of law the force of law. Right? But a lot of other provisions are programmatic. Directive principles are clearly designed to be programmatic. There is a long gestation period. There's the idea that they will be enforced over time. But a lot of rights have a similar feature. Right to equality and non-discrimination clearly has that feature. Even things like freedom of speech, that even though constitutions guarantee at the start, you need a lot of social conditions to be conducive to the realization or free trial. So I think you're quite right in suggesting that the line between rights and directive principles is not necessarily that sharp. In fact, one of the stories that I haven't told because the literature already has focused on that quite a bit is that even though there's a bar on judicial enforcement of directive principles, courts have still gone on to do other things short of enforcement with these principles. But
actually, I have a question that relates to
yeah.
So the one actor that obviously the enactment of a directive principle excludes is the courts. And one wonders why the framers didn't think that the courts might be the body that would be appropriate to settle these differences in the future. Right? So in light of the fact that so much power is given to the judiciary under the Indian Constitution, one wonders why these topics were, as it were, removed from the purview of the courts, especially assuming that the courts would have a liberal democratic mandate that would color the way in which they would handle it. Listening to your talk makes me think a bit of the Canadian Constitution. There are various ways in which we've done this in incrementalist or programmatic terms, right? So our Constitution entrenches the notion of Aboriginal rights, for example, which, and treaty rights, which might even possibly include non-so-called liberal ways of thinking about the world, and just pushes it out there to the courts. So why is it that we think that in the Indian sort of evolution of things at the moment of constitutional drafting, suddenly the courts are not thought of as the appropriate arbiter of these questions, right?
So there are two ways of doing it. One possibility might have been that the Constitution still does its partial deferral, which is that it still settles the goal that these directives must achieve and judicializes them. That would have been a liberal nightmare, because the Constitution is requiring the courts to prohibit cow slaughter. In fact, that's what the nationalists want, right? So, like Hindu nationalist members stand up in the assembly and say, we want the anti-cow slaughter prohibition provision in the fundamental rights chapter. And then some members say, look, that's for humans, not animals. And there's some but anyway, it's not a facetious point. But liberals would not have accepted that, or did not want to accept judicial enforcement of what they saw as an illiberal agenda. But if you left the question open and did a full deferral, which is that this is a question that the courts will settle 20 years down the line, then you're probably not giving enough to the dissenters, who will exactly along your worries think, well, this is a liberal constitution, the courts are likely to be liberal too, and they're going to decide against us.
Okay. So just as a follow-up, so you just pointed out in the answer to the first question that the courts have sometimes looked to the directive principles as something that should really forcefully inform the interpretation of other rights, right? Here I'm thinking of the right to food in relation to the right to life, for example, right? So what you said, that public health ought to be a directive principle, and yet the court's saying, well, we need to really piggyback on this to really press on the interpretation of other rights. Is that something that is widespread? Do you see of this more happening? And is that something that was contemplated?
So it's not clear how, so they didn't want courts to enforce it. Well, the framers who put this as directives did not want courts to enforce. A lot of, especially socialists, were vehement until these divisive directives got into the constitution. They really wanted the social rights directives and the distributive justice directives to be judicially enforceable. Now, the language they use is different from the Irish constitution. The Irish constitution says the court shall not take cognizance of. Mm-hmm. The Indian constitution says the court shall not enforce, which the Indian courts have used to say, look, our prohibition is different, it's limited. It's only against direct prohibition, direct enforcement, but we can use them as interpretive aids, which they have done. They have used directive principles as deference demanding tools from the judiciary to when Parliament enacts a law that is ostensibly in pursuit of a directive principle and also infringes upon a fundamental right, courts are more deferential. The third thing that you mentioned is some directives, some social rights directives have been transformed into fundamental rights by being read as implied rights under the right to life in the Constitution. Part of, there are a few comments in the paper, again underdeveloped because I'm trying to do something else. Part of the point of this paper is to think of the directives as belonging to different categories. Although the Constitution itself does not have this categorization, in the debates is very clear that the framers think of it as different categories and imposing different types of duties on the state. So the categorization I've used in the paper are uncontested directives. There's the first category where there is no contest, no disagreement about the content of the directive. And these are all the social rights directives. Everybody agrees that the state should secure these things. The disagreement about them is their status, where some people think they should be directly enforceable by courts and others demand them to be directives. But the content is uncontested. And those are the directives that the courts have actually made enforceable under Fundamental Rights chapter. The second set of directives are the partially contested directives. Now these are directives about economic democracy. These are the redistributive directives. Now the disagreement here is this. Nobody in the assembly thinks that these are inappropriate goals. Nobody thinks that it's inappropriate for the state to seek them. Right? So in that way, like the libertarian voice is completely absent from the assembly. What they do disagree about is what's the best way to get there. Right? And that is where the socialists and the capitalists divide. And Ambedkar quite clearly, and Nehru, tell the assembly, look, we have particular political commitments. We think that a big state, socialist state, should best achieve it, but we don't want to put the means in the Constitution. We have specified the ends, but the means must be open to political battle. Go convince the electorate and then pursue those means. And the third category are the divisive directives, the deeply contested directives that form the focus of this paper. And it's very, at least Ambedkar, when he's, and I'm not being an originalist when I keep invoking what he said, but at least Ambedkar is very clear that the three types of directives impose different types of duties on the state. And on the deeply divisive directives, the when question, he leverages that to say the only right time to implement these directives is when the state has secured sufficient consensus, when they are no longer divisive directives.
I see.
Which is interesting, right? Because that effectively means that it's a duty, but it's not really a duty.
But that's not laid out in the Constitution itself.
No,
it's just
no. This is all. So hopefully, the court will start seeing that distinction sometime.
Yeah, Professor Davis.
You already answered one of my questions by talking about the difference between cognizance and enforcement. My other one has to do with the phrase directive principles. mean, there's the familiar distinction in administrative law between mandatory and directory, which I assume in some way is related. And I'm just wondering, have you done a full genealogy of how they chose that particular phrase, directive, rather than something else? And are they principles in the wording, or are they directives, period?
Most of them are not principles. They're highly specific rules. And in fact, that was quite key to the containment strategy, because they wanted to rule out certain reasons. They settled on directive principles mainly because of the inheritance from Ireland. What they did change something. The Irish provision is called Directive Principles of Social Policy. In the Indian Constitution, it calls them Directive Principles of State Policy. They've actually been used, on my last count, about 35 to 40 states have a similar chapter in their constitution, and a lot of which are similarly worded, and various, they're called principles of state policy or directives of social policy, some permutation or combination of these types of words. But I've also found things in German and Austrian state constitutions which are called state tasks. I don't know the original, but at least in English they're translated as state tasks. I'm told that a lot of European Union law does similar work through recitals, where different agendas are put in the recitals before the legislation. So every time I present this, somebody will come up and say, "Oh, my jurisdiction has something similar." So it seems like a ubiquitous, or at least a popular enough tool to have merited a lot more scholarly attention than it has. I think it's the dominance of American, U.S. scholarship on constitutional theory that they've mostly been ignored by scholars so far.
That was really fascinating. I'm particularly interested in this because coming from Pakistan, obviously the comparisons are tremendous. There was this one thing that I was wondering. You say that this is a partial deferral, but the experience that we've had in Pakistan with the objectives resolution and with the principles of policy and stuff, you've seen things like Islamic provisions in the constitution, similarly like language provisions in the constitution. They haven't ended up being deferrals as such because they become so much inherently part of the constitution that even after the time lapse or whatever, it becomes something which is beyond political challenge. Like Islamic provisions are never going to be seriously challenged by any political party in Pakistan. And that is something that I find problematic in the sense that you may call it at that time a way of kind of furthering it down the road, but it doesn't happen in practice. I mean, with the language thing that we saw in Pakistan, it was supposed to be something that was supposed to be revisited. But Hindi or Urdu in Pakistan, you've had that as a sort of a kind of a political negotiation. Urdu is not the language of, Sindh or the other provinces. And that political fight, in a manner of speaking, has been subsumed by its constitutionalization. How would you call it a deferral then? Because it's become far more entrenched. It's acquired a greater deal of legitimacy.
So the deferral is happening at the moment of the framing of the constitution. Right? So I don't know the Pakistani provisions, and we should talk because one of my future projects is I hope to look at South Africa, South Asia as a region more generally. So I'd love to learn more about Pakistan. But what is being deferred is the partial decision at the time of framing. Now, of course, it may well be that in the state further down the line, some of those decisions become politically enacted and they become entrenched. So decentralization of power to villages in India, I don't think any party can overturn that. It happened in the early 90s, in 1991. It happened in this contained manner. There's no self-sufficiency in there, but there's a third layer of government at the local village level. And there's now sufficient political consensus that's become quite stable. Now, it became stable in part because the main fear that the Liberals had was addressed as part of the implementation. So the main fear was that villages are extremely deeply hierarchical and inegalitarian places where women and lower caste groups, in quotes, will be permanently locked out of political power. And when power is devolved to the villages, it comes with very robust quotas for women, 33%, at least in some states to 50%, and caste groups in accordance with the. So that's what made it acceptable. Now, it's true that if the group which has this agenda captures power, it will try to implement it. And because these are by nature divisive questions, they have a strong inertia. Once a question is settled, any pragmatic politician would think twice before reopening it because it brings with it its own instability. So the language policy in India, no sane politician would reopen it, but we have our share of insane politicians. So maybe so I don't know the history and the context enough to answer your specific question, but I would think that the political entrenchment, the political movement would require the radicals whose agenda it was to capture power and implement it, and later inertia is understandable because it's just the sort of thing, it's the hornet's nest, you don't want to touch it.
But given that kind of inertia, can you seriously say that it was a deferral that was intended then?
It was a deferral at the time of framing. So it will not be deferred forever, right? As in, so in 91...
The inertia could become a resolution.
The inertia could itself be the resolution, absolutely, right? The deferral is a temporal thing, right? You only defer something today to do tomorrow, but if you've done it tomorrow, then you're no longer deferring it, right? So that's all I'm saying, that the deferral is to shift the decisional weight from today to sometime in the future.
Yeah.
And that's important for framers because they want everybody to agree to this document now.
Professor Ryder.
Thanks, Francois, and thanks, Tarun. It was so interesting to learn about this topic and to learn a little bit more about the Indian Constitution. I'm a little embarrassed how little I do know about the Indian Constitution, and a little embarrassed at how little comparative engagement there has been amongst Canadian constitutional scholars as a whole. Over the years. I mean, we tend to, I guess for obvious historical reasons, engage with the UK tradition, and for geographic and political reasons, mostly with the US, but more recently, more so with, I guess, South Africa and also Australia and New Zealand when it comes to Indigenous issues. But kind of you map Canadian comparative engagement at on constitutional issues. It's a bit surprising how little there has been with India, and I'd be interested in any reflections you have about why that might be and what we might do to overcome it. But before, I hope you can say a few words about that, but I just wanted to offer a few observations. I was thinking, it's such an interesting topic, non-justiciable principles that are nevertheless fundamental to the governance of the state and of the country and binding on the state. And I'm trying to think of, well, it's so fascinating to hear about their origin and hear how they played out politically and in courts as well. And I was trying to think of whether we have anything that's comparable, because, of course, we don't have a section in any of our constitutional documents that says non-binding, directive principles of state policy. But we do have some very related examples, and two came to mind in particular for me. Excuse me. One was at the time that we adopted the 1982 Constitution, we weren't quite sure what role Aboriginal people should have in the future of the Constitution and what role they should have in constitutional amendments. And of course, agreeing on an amending procedure was such a difficult project that took us many decades. To address that issue at the same time was kind of thought to be overburdening the 1982 settlement. So we deferred it. to a conference to which representatives of Aboriginal peoples were invited, and it couldn't agree. So what we have is Section 35.1 of the Constitution Act 1982, which essentially says Canadian governments are committed in principle to the idea that they will consult with Aboriginal peoples before they make an amendment to the Constitution in relation to their rights, which is very weak in some senses, but I think shares some of the same objectives that you mentioned. That is, it's an example of deferral. It's an example of giving a stake, and a very important stake, I think, to Aboriginal people, so that if there ever was an attempt to amend the Constitution without consulting them or without their consent, I think it would be considered deeply illegitimate, notwithstanding the weakness of that provision. But it's a kind of directive principle.
Yeah.
And the other example that came to mind really is a product of judicial thinking, so kind of raises the question of whether judges are interested in developing principles that function in the same way as these provisions of the text of the Constitution do. Because I think in Canada sometimes they have. And the example that came to mind for me was in the secession reference. The Supreme Court of Canada said that in the future, if there's another referendum on sovereignty, and there's a clear yes vote on a clear question, there's a duty on all of the participants in Confederation to sit down and negotiate in good faith towards a settlement. And it's a legal duty and a constitutional duty. It's binding on all governments, but it's not justiciable. And I'm not quite sure exactly why that is. We won't enforce it. We'll leave it to the political actors to figure out exactly what that means and how it will play out, and what counts as a clear question and what counts as a clear majority, and all those very difficult things. And the federal parliament tried to set that out in the Clarity Act, and Quebec had passed legislation that expressed a very different view. But again, I guess you can see that as an example of a court saying, these are extraordinarily difficult issues. We don't want to try to resolve them all. We don't even want to be involved in enforcing them down the road, but we'll leave it to you to work them out, because if we tried to do it all right now, it would not necessarily lead to the kind of unity we're seeking to promote here. I'm sorry for...
No, thank you. So, as you were talking about what else might be there, to answer your second question first, British constitutional lawyers have long known constitutional conventions, which do pretty much a very similar task, and you know, your amendment issued where the court recognizes the convention but does not. I'm at the limits of my knowledge of Canadian constitutional law here, but I think Canadian constitutional law recognizes something similar to the idea of conventions. Even in the U.S., I presented this paper at NYU, and I was told that the American Constitution has what are called under-enforced clauses, and even speaking to somebody about the gerrymandering cases recently, where it is unconstitutional to gerrymander constituencies to benefit your political party, but the courts are not going to enforce it. It's not illegal in the sense that it's actually permitted as a defense against a disparate impact case. So I think that, you know, non-enforceability is a feature of all constitutions. Some do it more explicitly, some don't. And there's I've seen a draft paper of a scholar from Melbourne called Lyle Weiss, and she talks about 3 different reasons why framers put directive principles in certain constitutions, and she calls them resource constraints, epistemic constraints, and deep disagreement. And you can see, you know, resource your fuller type idea of this is a polycentric question. Courts should not deal with it, and that's what's going on with some of the social rights and redistributive cases. And epistemic constraints, she mainly talks about environment cases where the courts just don't have enough knowledge and expertise, and therefore let the political branches deal with it. But you can see that Ambedkar's defense of not putting socialism as the way to get economic democracy is also an epistemic question. He explicitly says, do we really know which is a better route to these goals? and of course, deeply divisive questions whether courts better stay out is just, wise on their part. So I think that, in a different world where American scholarship was not so dominant, this is my bridging your two questions, we might have seen more on other constitutional duties that address other institutions. And in fact, there's a reason to think that even rights, at least I think it's a better way to think about rights, to see them as addressing primarily the political organs of the state. The courts come in later when there is breach to fix things. But it's not a happy state of affairs when parliaments and congresses don't think it's their duty to respect fundamental rights. So anyway, but on the scholarship question and sort of scholarship within the Commonwealth in some ways, I think it's a great shame that we have so little comparative constitutional law, especially on the Westminster system. One of the projects that I hope to do, and do it someday, or at least educate myself on, is just how thoroughly unsuitable the presidential model is for divided and pluralistic societies. Why almost every authoritarian democrat wants to amend the constitution to move to a presidential model, right? Indira Gandhi wanted to change India's constitution to make it a presidential system. The first time the Hindu nationalists went power in the 90s, they want to amend the constitution to become a presidential model. And so but that's the model that gets exported because there's so much more literature on the American system, and every new country decides to adopt it. And I don't know, I think a study of Westminster systems outside of the UK and codified Westminster systems, right? Because Canada and Australia and India, they've all put down rules and tinkered with how to best design the system to suit local conditions. I think there's a wealth of practice there waiting to be analyzed and theorized.
Yeah, I agree. And it seems like the patterns of engagement or the flow of ideas tends to follow distinctly colonial patterns.
Totally.
I think it's maybe been
Unidirectional.
challenged in some ways, but it's a little troubling.
It is mostly in one direction. I think part of it is also the fact that Indian legal scholarship is still developing. It's early days. A lot of the scholarship that is available is mediocre. Some of the stuff is brilliant, but it's hard to find, it's hard to look for. It's scattered, it's fragmented. Some of it is out of print. So there are practical challenges even for the willing to do it. Yeah. But at least the question of challenge of language isn't there. Most of the stuff in all these jurisdictions is in English. So,
Darren, are you conscious of this notion of directive principle as framed in the Indian Constitution having played any kind of role in the genealogy of constitutions? So have constitutions thereafter looked back to what India did and absorbed this idea in any specific way in constitutional debates around the world? It just seems that you've mentioned Ireland as something that Ambedkar might have looked at, right? So is it still the case that would be the default case, or has India become a kind of...
Oh, Ireland is the outlier. When it comes to the modeling of directive principles, it's the first two type of directives in the Indian Constitution that have traveled across Asian and African democracies, well, at least when they were being framed, and sometimes not even as democracy. The Nigerian Constitution was framed by military rulers. So it travels around the decolonized world, but the provisions that travel are the first two sets, the social rights. And what I haven't seen is whether these other contexts are also using the directives in these creative ways. But after Nigeria borrows from India in the 70s, I believe 60s or so, I'm not sure the date, and then it goes to almost every single African country that writes a constitution after that. Even Nepal, which wrote its constitution last year, has a chapter on directive principles. So they are ubiquitous. You find them just about everywhere.
The role played similar to directive principles or constitutional conventions. So in the United Kingdom, for example, they have that, and they've got that current case in the High Court about whether Brexit can be triggered by royal prerogative or requires Parliament. Are there constitutional conventions? I should say in Canada, our Supreme Court has sometimes recognized constitutional conventions, including in the secession case, even though we do have now a fairly written constitution. Obviously, India went to a detailed written constitution in striking contrast to the colonial power. Are there constitutional conventions as well?
Yeah, it's not received, like a lot of Indian law and scholarship, it's not received the scholarly attention that it has, and it becomes a self-fulfilling vicious cycle, because if scholars don't pick it up, then courts don't refer to it and advocates don't argue it in court. But of course there are constitutional conventions, like even the most detailed constitution cannot write down everything that the state is going to face in future. So for example, it's the role of the president to invite the leader in the lower house of parliament to form the government. Right? Now in the 90s, when we start having hung parliaments and coalition politics, often it's not clear who the leader of the house is, and then various presidents struggled with the question of what convention to develop, what is the practice been, because there's no single largest party. Some presidents started. So yes, there's I think in any written constitution there will be space for conventions to grow around it.
Different question. Please correct me if I'm wrong. I believe there are provisions for tribal areas in the Indian. Is that correct? And that have some rough correspondence to our Aboriginal challenges. I'd be interested in whether the directive principles approach was applied to that.
So I think there is one directive that talks about the state needing to make particular efforts to improve the conditions of living for caste and tribal groups. But the provisions that you are referring to, they use the language of autonomy, not sovereignty. So there is no sovereignty rests with the people as one people. There is no sort of division of sovereignty, but there are special autonomy provisions which give these tribal areas special decision-making powers, which can diverge from the laws of the state that they're located in.
Are they controlled by contextual provisions like you described for the other directive principles?
So yeah, they are contextual in the sense that there is no general formula that governs all tribal areas. They are very specific. So there is a default scheme of federalism, but there are special provisions both for certain types of states that require different treatment. So Jammu and Kashmir, for example, has a lot more autonomy than any other state. It's the only state that has its own constitution. And then within states as well, all the departures are specified as particular cases in the constitution, and that's partly the explanation for its length. Instead of dealing with these departures as broad principles, the constitution provides very specific and clear rules.
One last question from me. Given that these principles, these directive principles, are part of the constitution, and that the gloss that you mentioned that Ambedkar sort of had in mind about the deeply controversial ones is not part of the constitution, can we meaningfully say that India has a liberal democratic constitution, or is it something else as a result?
It has a democratic constitution. I think it has an aspirationally liberal constitution, and the liberalism is located in the Bill of Rights. But because they are also programmatic, the constitutional language is still not the societal reality. So is India a liberal country? I think that's a very tall claim to make. Would the constitution like India to be a liberal country? I think so.
Despite having these principles, which are sometimes ecologically slanted.
Absolutely, absolutely. So what's clear in the Constitution is, despite the deference for directive principles, is that they still need to respect fundamental rights.
Yes. Okay, one last question.
Yeah, it's not so much a question. I was just doing a little look to see if I could find anything quickly that we have that's comparable in Canada. The closest that I've come is when British Columbia was entering Confederation, the federal government obliged itself constitutionally to build a railway to the West Coast. And that's been discussed judicially in terms of what that meant when the Vancouver Island Railway became economically inefficient. Was there still some constitutional obligation? And the court danced around different kinds of obligations in that discussion.
That's fascinating.
Well, on this note, I'd like to thank Tarunabh for a wonderful presentation, which really emphasizes why we should be doing more comparative work, given the possibility for cross-pollination and the kind of engagement it allows and the kind of ideas it triggers is just phenomenal. So thank you very much, and here's to hoping that you're going to come back again next year to present. Thank you very much, Tarunabh.
It's been a pleasure. Thank you.